तो मैं गांधी की तरह इस कानून को फाड़ता हूँ।
संसद का कानून है, सबको स्वीकार करना पड़ेगा।
मैं इस्लामिक देशों का नाम पढ़ूंगा जहां वक्त का वजूद नहीं है, तुर्की में नहीं है, लीबिया में नहीं है, इजिप्ट में नहीं है, सूडान में नहीं है, लेबनान में नहीं है, सीरिया में नहीं है, जॉर्डन में नहीं है, तुनीसिया में नहीं है।
संविधान का आर्टिकल 14 हो, 29 हो, 30 हो, चीख कर कहता है कि देश में सब बराबर के हकदार हैं।
वक्त की रुखसती का वक्त आ गया है और वक्त की नई सुबह होने का वक्त आ गया है।
But today the tone, the tenor, the atmosphere in the house, I think is not comparable to what may have happened in 2013.
नया मुल्ला प्याज ज्यादा खाता है, परंतु यहाँ तो जो गैर मुल्ला प्याज बहुत खा रहा था और इतना खा रहा था कि आंसू निकल रहे थे गरीब मुसलमान के भी और देश के भी।
The much controversial and the center stage of heated debates in the parliament, the Waqf bill is now an act after receiving the final seal of approval from the President of India. This law has once again stoked the secular emotions in the country, much like the CAA of 2019. While the government says that the Waqf Act brings in accountability, transparency and justice to the weaker and outlier sections of Muslim society, the opposition has termed it as an act to silence the Muslims and weaken their rights. So does the devil lie in the details of the act? Let's simplify and explain how the Waqf Act affects the various stakeholders. This story begins centuries ago under the sun of Islamic traditions. Waqf means a gift, a property donated forever for charity or worship, like mosques, schools, or shelters for the poor. Once declared a Waqf, the property is permanently committed to purposes such as building mosques, schools, or shelters, with any income generated earmarked for the community's benefit. In India, this noble idea took legal shape in 1954 with the first Waqf Act. Fast forward to 1995 and a new law replaced it, handing the reins to Waqf boards, groups tasked with managing these lands. In 2013, the law got tweaked, giving these boards more muscle to call any property a Waqf. However, soon after the Waqf Amendment Act of 2013, tales of mismanagement and corruption by the Waqf boards started getting traction. The marginalization of women and lack of diversity in the constitution of Waqf boards was heavily criticized. Further, the claim of properties left and right, even the government ones, their irrevocability and the lack of judicial oversight further compounded the problems with the management of Waqf properties. The Waqf Amendment Act of 2025, tabled by Union Minority Affairs Minister Kiran Rijiju in the Lok Sabha on Thursday, April 3, 2025, aims to address these issues and challenges in regulating and managing Waqf properties.
Shri Kiran Rijiju to move motion for consideration of the following bills. The Waqf Amendment Bill 2025, the Musliman Waqf Relief Bill 2025.
A special parliamentary team, the JPC, studied the bill and agreed that things need fixing.
Of the Waqf Amendment Bill 2025 and the Musliman Waqf Repeal Bill 2025 as passed by Lok Sabha.
To get a full picture, let's compare the old Waqf Act of 1995, updated in 2013, with this new amendment under 4 major subheadings. Number 1. Retention of Waqf by user. The new act retains the Waqf by user doctrine, which recognizes religious use over time as a valid Waqf without formal documentation. However, this is only applicable to properties registered before the law's enactment, but bars its application to future claims unless proven otherwise. However, the opposition has criticized the controversial clause requiring individuals to prove they have practiced Islam for at least 5 years to create a Waqf, raising concerns about exclusion of recent converts. Number 2. Inclusion of non-Muslims in Waqf institutions. The Act allows non-Muslims in key Waqf bodies like Central Waqf Council and State Waqf boards, and a non-Muslim to be the CEO of the Waqf board. The opposition leaders argue these provisions dilute community control and interfere in religious autonomy. But the government says they aim to boost transparency and expertise. Third is enhanced government oversight in property surveys. The revised Act strengthens bureaucratic control over Waqf property surveys by designating officers above the rank of district collectors to conduct surveys. These officers will act as final arbiters in property disputes, replacing Waqf tribunals under the 1995 Act. The opposition has hailed it as clipping the powers of the Waqf tribunals and raised the fears of unbridled government control. The government cites misuse of Waqf laws and past irregularities such as the UPA's transfer of 123 Delhi Waqf properties as their justification. And lastly, streamlined registration and audit mechanism. The amendment also mandates that the big earning Waqf outfits must open their books for audit via a new central Waqf management portal for transparency, a centralized platform for registration and oversight. Despite the passage of the Act, the tale's far from done and questions continue to linger. Opposition parties have been crying foul, calling it divisive, anti-constitutional and a black law aimed to usurp Muslim properties. It's a clash of trust, faith, and who gets to hold the keys to billions in property. Will this law really make things clearer or just pile more on rules? Can non-Muslims on Waqf boards bridge gaps or widen them? Is the government tightening its grip on faith itself? And what does this mean for Muslims and all minorities in India's big, colorful family? These aren't just questions for the lawmakers. They are for all of us to ponder as India steps into a really uncertain tomorrow.